So the topic for the panel is how to create value. And what we realized is that there are a lot of ways to create value. Model 1 is to innovate, protect your innovation with IP, create your own market. And that's the value creation model that we tend to think of when we think of IP. But there's another model which is actually more important, and that is having a product and bringing your product to market that you want to exploit. Unfortunately, very many times when you want to use a model to bring a product to market, there are a number of different types of IP that is in the way, that third parties and competitors have IP that will stop you from entering that market. Well, the United States has undergone a considerable shift in the years since the AIA was passed and came into effect in 2012. That statute provided a number of different techniques for invalidating patents at the patent office. At the same time, the Supreme Court has ruled in a number of cases that restricted patent eligibility and made more opportunities for invalidating patents. So patent protection in the US has been weakened, which makes the first model, the model of innovating and exploiting a market protected through IP, makes that a little bit less attractive. So this is just an example of what's been happening in the United States. Allergan, it's an important drug company. It used to be based in Orange County. Now it was purchased and is based overseas. But they had this drug for restasis, and it was an important product for them. But their patents are no longer in place because they were challenged in one of these proceedings that was made available under the AIA. So I said that there were different proceedings now under the AIA. Before the AIA, it was very limited what could be done at the patent office to block a patent. There was something called inter partes re-exam. This was a hybrid proceeding that involved an examiner and two different parties giving written comments to the examiner. And there was ex parte re-exam. Ex parte re-exam is somewhat disappointing and usually for the person who wants to challenge a patent because the challenger is only allowed to ask for ex parte re-exam to be initiated, and then once it is initiated, it becomes an ex parte, meaning by themselves, proceeding with the patent office and the patentee. So ex parte re-exam is often disappointing because the patentee can amend the claims, can have an interview with the examiner, do anything that you would do during initial prosecution, and usually get the patent through again. After the AIA, inter partes re-exam has been replaced. It's been replaced with three different proceedings. Post-grant review, which we usually use the acronym PGR, a transitional program for covered business methods, and we usually use the acronym again there, CBM, and inter partes review, again the acronym is IPR, and not to be confused with intellectual property rights. In the US, when we say IPR, we're usually talking about these inter partes review proceedings. And this is the type of proceeding that has occurred more than any of the other two. And this chart shows a quick comparison between the three different types of proceeding. They're all very similar. The difference really is in the types of patents that are eligible and the types of challenges that can be made. So an IPR can be made against any patent, and the only difficulty is that it has to be brought within 1 year if there's a pending lawsuit. So if a lawsuit's been filed, a challenge to the patent that's in suit has to be brought within 1 year of the filing of that lawsuit. it can only be brought on the grounds of prior art, and it's got to be printed publications or patents. So it has limited subject matter for invalidity, but broad applicability to any patent. PGR is a little bit the opposite. The patents that are eligible are patents that were granted under the first to file provisions of the AIA, and that means that it has an effective filing date of March 2013 or later. But the grounds that are available are very broad. You can challenge the validity of in a PGR on any grounds, as long as you file this PGR within 9 months. And after 9 months, then you have to go back to IPR, and you lose the right to challenge on these non-published prior art reasons. CBM is this very narrow category for financial transactions. It was financial patents. It was meant to allow a PGR-like challenge to a patent, even though it's not an AIA patent, so that a patent that relates to financial transactions can be challenged on the grounds of patent eligibility. So because AIA patents haven't been around for that long, there have only been a very small number of PGRs. And CBMs are only for financial transaction patents, and there have only been a few of those. So most of the ones that we've seen have been in the area of IPRs. CBMs, I mentioned, they're primarily in the area of financial transactions. I included this slide to see what happens to a case that ends up in a CBM. If you look down in the slide toward the bottom, you could see the second to third to the last lines in the slide. The institution rate for CBMs, if someone challenges a patent on a financial invention, you can see that the institution rate by the Patent and Trademark Office has been very high. It's about 84.6% have been instituted. So if you challenge it, 85% of the times it will be instituted. And in the next line it says, well, of those cases that get instituted, how many are found invalid for lacking patent eligibility? In other words, Section 101 patent eligibility, 97 point some percent of the time, those cases are found invalid. So CBMs, if you're the owner of a patent in a financial transaction and you get challenged under CBM, you have very little chance of coming out the other end. And conversely, if you want to bring a product to market and there's a financial transaction patent that's in your way, CBM looks like a very good way to get rid of that patent. I mentioned there's only been a few PGRs. We counted. There have been 15 filed. And of those 15, there's been 3 or 4 decisions. So there's not really a lot of information we can tell you about PGRs at this time because